United States citizens over a suspicion that they are not willing to prove, a suspicion that is cruel on its face, regardless of a person's status. I thought it was interesting that the judge, in his ruling, which was pretty brief, said this is going to cause operational chaos.
This ruling lands first, not last. A federal judge in New York has just blocked the Trump administration from freezing roughly $10 billion in federal funding, money earmarked for child care and core social services in 5 Democratic-led states. The order stops the punishment cold, the money keeps flowing, the states keep operating, and the administration is told in unmistakable terms that it cannot weaponize federal programs midstream to settle political scores. Picture the scene as it unfolded. Letters sent, funds halted, systems jolted, and then the court steps in and snaps the circuit back on. California, Colorado, Illinois, Minnesota, and New York were suddenly told the federal partner they rely on would not pay its share. Child care subsidies, cash assistance, job training, social services, programs serving 1.3 million low-income children. The impact was immediate, and the judge treated it as such. The shock here is not just the attempted freeze, it is the brazenness of the justification. The Department of Health and Human Services claimed it had reason to believe these states were providing benefits to what it labeled illegal aliens. No evidence, no specifics, no explanation for why only these states received notices. No explanation for why others did not. Suspicion offered as policy, accusation offered as proof, and punishment imposed before a single fact was tested in court. Watch the stakes rise in real time. States had already fronted the money. Providers were already operating. Parents were already relying on care so they could work. When the federal government reneges, the gap opens immediately. Payrolls wobble. Centers contemplate closures. Families feel the squeeze. The judge did not need hypotheticals. He saw the operational chaos coming because it was already beginning. This is where the administration's move collapses under its own weight. You cannot selectively pull funding from a handful of states in the middle of a fiscal year without detonating the systems you helped build. You cannot claim partnership and then behave like a saboteur. The court's message was blunt. This is not how federalism works, and it is not how the law allows power to be exercised. The ruling is brief, but its implications are not. The court ordered the funds to continue while the lawsuit proceeds, recognizing that harm delayed is harm delivered. Children do not wait for briefing schedules. Providers do not pause expenses because a political appointee wants leverage. The judge saw the imbalance and moved decisively to restore it. And here's the political reality the administration ran into. These are not abstract dollars. These are programs Republicans and Democrats alike have long treated as untouchable. You do not take food out of children's mouths. You do not destabilize child care so parents cannot work. You do not gamble with the social services that keep families afloat. That consensus has held through budget fights, shutdowns, and disasters. This move shattered it. The immediate consequence is now locked in. The freeze is blocked. The money flows. The administration is boxed into litigation it invited, and the court has already signaled how it views the conduct. Arbitrary, selective, and destabilizing. This is not a warning shot. This is a judicial hand on the brake, applied hard, with the understanding that the road ahead only gets steeper. Let's reset the trust here, briefly and cleanly. The audience already understands the basics of federal grants. What matters is the structure of reliance. States administer programs. The federal government promises reimbursement. That promise is not casual. It is the backbone of national social policy. Break it, and you break the system. The Child Care and Development Fund is not discretionary whim. It subsidizes care for working families, enabling parents to stay employed while children are safe. Temporary assistance for needy families provides cash assistance and job training, stabilizing households during transition. The Social Services Block Grant supports a wide range of essential services. These programs are authorized by Congress, funded by Congress, and administered through rules that assume continuity and good faith. Now watch how the administration tried to reroute that machinery. Instead of auditing, investigating, or litigating first, it sent letters asserting suspicion, not findings. Suspicion. It then froze funds immediately, targeting only Democratic-led states. No explanation for why red states were spared, no public accounting, no due process. That sequencing matters because it reveals intent. In law, motive can be inferred from method. Here, the method was selective punishment without proof. The judge read it the same way. He warned of operational chaos, a phrase that carries weight in administrative law. Courts defer to agencies when agencies act predictably, transparently, and within statutory bounds. Courts intervene when agencies yank levers unpredictably, especially when vulnerable populations bear the cost. Consider the federal-state relationship historically. It has been tense at times. Yes, FEMA disputes, healthcare waivers, environmental standards. But even in those fights, there is an underlying norm. The federal government does not abruptly default on obligations to score political points. That norm is not courtesy. It is necessity. The administration's explanation collapses further when you examine the alleged concern. If there were credible evidence of misuse of funds, the law provides tools, audits, compliance actions, negotiated remedies, litigation. None were used first. Instead, a freeze. That is not enforcement. That is coercion. And the coercion is political on its face. Blue states named, red states silent. The administration acts as if Republicans do not live in California or New York, as if conservative families do not rely on childcare subsidies, as if economic reality stops at partisan borders. It does not. The judge's intervention resets trust not because it favors states, but because it enforces process. Funds continue while the case proceeds. Evidence will be tested. Claims will be examined. That is the rule of law functioning as designed. The court did not decide the ultimate merits. It decided that the harm of unilateral punishment outweighed the government's unproven assertions. This matters politically because the administration campaigned on affordability. Childcare was supposed to be fixed. Tariffs were supposed to pay for it. Promises were made without details, then repeated without delivery. Now, nearly a year into office, childcare remains expensive. And the administration's most concrete action in this space is to freeze subsidies to punish states it dislikes. The explanation phase ends where the escalation begins. The court has forced the administration back into a form it cannot dominate with press releases. Judges demand records. Judges demand consistency. Judges demand reasons. And judges, as this ruling shows, are not inclined to let children become collateral damage in a political standoff. Now the pressure tightens. The administration is no longer operating in the realm of messaging. It is operating under judicial supervision. That changes everything. Every claim must be supported. Every inconsistency will be exposed. Every selective choice will be scrutinized. The judge's rejection, though temporary, signals skepticism. Courts do not invoke operational chaos lightly. They do it when an agency's action threatens to unravel programs nationwide. The administration tried to frame its move as compliance enforcement. The court treated it as destabilization. Watch the escalation through repetition, Freeze announced. States sue. Court blocks freeze. Funds restored. Lawsuit proceeds. Each step narrows the administration's options. It cannot quietly walk this back without admitting error. It cannot press forward without producing evidence it has not shown. And it cannot ignore the court without risking contempt and further rebuke. The legal terrain here is unforgiving. Administrative law requires reasoned decision-making. Equal protection principles frown on selective enforcement. Spending clause jurisprudence limits the federal government's ability to coerce states by threatening funds unrelated to the alleged violation. The administration's move brushes against all three. Judges understand leverage. They also understand when leverage becomes abuse. By freezing funds already promised, mid-year without findings, the administration turned partnership into hostage-taking. The court stepped in because the Constitution does not permit governance by threat. Politically, this escalates beyond a single case. Other states are watching. Agencies are watching. Providers are watching. The message is clear. If the administration can do this to 5 states today, it can try to do it to others tomorrow. Courts exist to stop that contagion. Financially, the exposure grows. If the administration loses on the merits, it will face not just an order to pay, but a public accounting of its rationale. Discovery will probe internal communications. Decision chains will be mapped. Selective criteria will be revealed. That is not a comfortable place for an administration that prefers discretion without disclosure. And then there is Congress. Lawmakers who appropriated these funds will not ignore an executive attempt to reroute them for political punishment. Oversight hearings follow patterns. This case fits one. Subpoenas do not respect spin. The administration's defenders may try to reframe this as immigration enforcement by other means. The court has already rejected that framing implicitly. Immigration policy does not authorize cutting childcare subsidies to citizens. Even if misuse were proven, remedies must be proportional and lawful. Collective punishment fails both tests. As the case moves forward, each filing adds weight. Each order adds constraint. The administration's initial shock tactic has backfired, converting a discretionary threat into a controlled legal process. That is escalation of the most dangerous kind for those who rely on unilateral power. The court did not just pause a policy, it forced a reckoning. And that reckoning will unfold in public, under oath, with records attached. The administration wanted leverage. It has instead invited exposure. Here's where image collapses into reality. The administration projected toughness, control, and resolve. The reality is fragility under scrutiny. When pressed to show its work, it froze. When challenged to justify selectivity, it deflected. When confronted with harm to children, it shrugged. The image was decisive governance. The reality is unreliable partnership. States cannot plan when the federal government behaves like a capricious creditor. Providers cannot operate when reimbursements become political favors. Families cannot budget when stability is sacrificed for theater. Now the options narrow and all of them are bad. Option 1, produce evidence supporting the suspicion. That invites examination of why only certain states were targeted and why enforcement tools were skipped. Option 2, settle quietly. That reads as retreat and confirms the weakness of the original move. Option 3, press forward defiantly. That risks a broader injunction and reputational damage across agencies. None of these paths restore the image. They all reinforce the reality the court has exposed. Governance by suspicion is not governance at all. This is where the rule of law framing becomes unavoidable. The Constitution divides power for a reason. Spending authority lies with Congress. Administration lies with agencies constrained by statutes. Adjudication lies with courts. When one branch tries to shortcut the others, courts respond. Not rhetorically, operationally. The judge's order keeps funds flowing precisely because law prioritizes continuity when harm is irreparable. You can repay money later. You cannot rewind a child's lost care. That principle is settled. The administration chose to test it. The court reaffirmed it. Politically, the fallout accelerates. The administration campaigned on affordability and competence. This episode broadcasts the opposite. It shows a willingness to harm citizens to score partisan points and an inability to execute policy within legal bounds. That combination erodes trust faster than any speech can rebuild. Institutionally, agencies feel the chill. Career officials understand the risk of arbitrary directives. They document, they dissent, they protect themselves. That slows execution and increases leaks. Control slips. The image of strength dissolves into the reality of constraint. Courts constrain. Congress constrains. Law constrains. That is not sabotage. That is design. And when an administration collides with that design, it does not win by force. It loses by exposure. The humiliation phase is subtle but real. A brief order, a plain warning, a forced pause. No grandstanding, just a judge noting chaos and restoring order. Power reduced to process, threat reduced to paperwork. The consequences now unfold predictably. Litigation proceeds, discovery expands, oversight sharpens, allies distance themselves, opponents organize. The administration spends time defending a move it did not need to make and cannot convincingly justify. Financially, the programs continue, and the states document every cost the freeze threatened to disrupt. That record will matter. Politically, the narrative hardens. An administration that talked affordability and delivered punishment. Institutionally, trust erodes where cooperation is required. The inevitable ending is not dramatic. It is procedural. Courts enforce limits. Funds remain conditioned on law, not loyalty. Selective punishment fails. The administration learns again that power exercised without proof invites correction. Picture the final frame. No triumphant announcement. No victory lap. Just an order on the docket, funds flowing as they should have all along, and a lawsuit grinding forward. The spectacle fades. The consequences remain. This is how the rule of law asserts itself. Not with slogans, but with injunctions. Not with outrage, but with orders. Not with chaos, but with continuity restored. The administration tried to turn suspicion into leverage. The court turned leverage into liability. And the system, designed to protect the vulnerable from arbitrary power, did exactly that. There's no speculation here. The path is set. Evidence or retreat. Accountability or exposure. The ending is not in doubt. It is already underway.